So this morning we are going to have a webinar on child protection learnings from working with First Nations families. My name is Penny Sullivan from the Community Legal Centres Queensland team. Before we get started officially, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they're the Turrbal and the Yagara people, and I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout this country and extend a warm welcome to any First Nations Australians listening today. So we're really excited to be able to present this webinar today, and we're going to be joined by Michelle Bavis, who's a lawyer at the Institute for Urban Indigenous Health, to talk to us about the work that the IUE legal team has been doing with First Nation clients who've had some form of child safety intervention or are at risk of intervention. Michelle will share insights on systemic issues and the opportunities for legal practitioners to help mitigate risks for clients, culturally safe referral pathways, and the importance of developing good working relationships with decision makers. I'm going to let Michelle tell you a bit more about herself when I hand over to her in a moment, but just a few matters of housekeeping first. Today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints and the other materials have been emailed out to everyone who registered, and they're also available to download from our website and from the handout section of the GoToWebinar control panel. There are two ways you can ask questions. You can press the button that looks like a hand. We'll see the hand go up and we can unmute you. Or the easier method is, and our preferred method, is for you to type your question into the question box on the control panel and we'll read your question out. We will hold questions until the end of the presentation, but feel free to type them in as you think of them. So that's it from me. I'm going to hand over to Michelle now to talk through the webinar, and I'll talk to you again at the end of the session. So thank you very much, Michelle, and welcome. You just need to unmute yourself.
Thank you so much. Oh, thank you so much, Penny, for the introductions. Hello, everybody. Thank you so much for joining us and for your interest in this webinar today. Firstly, I too want to acknowledge the traditional custodians of the land in which we meet and pay my respects to elders past, present and emerging. By way of introduction, I have been with IUE now. Sorry, I say IUE, that's the nickname we give the Institute. So I will be saying IUE. So for those of who are not familiar with the Institute, I will be saying IUE. I've been with IUE now for 2.5 years, and my colleague and senior principal lawyer Simone Matthews, who's here in the room with me, has been with the Institute for 4 years. I'm not a First Nations person, so I consider it an absolute privilege as a non-Indigenous lawyer to be working in this field, to be trusted by mob, to be able to work with them on their legal matters. So it is a real privilege to be in that trusted position. In terms of the presentation today, I want to preface it by saying that we don't come into this webinar with the indication that we're experts on this. We simply want to share our insights and learnings. Some of you, our colleagues out there in the field, are far more experienced at litigating these matters, so we recognise that we are not the experts in this. We simply want to share our learnings. The second thing I want to say on the outset is that we recognise child protection is important. The best interest of the children and being protected from risk of harm is an important thing that needs to happen, and we recognise the Department of Child Safety plays a significant and important role in this field. We simply want to share today the insights that we have in terms of potential areas for improvement that we see could ultimately improve outcomes for First Nations families. The way I want to present today is to share with you some of the systemic issues that we've identified and that clients have provided feedback to us in terms of the matters we've come across, as well as sharing with you the risk factors that we've identified as potential triggers for interventions, and also some insights in terms of practices that we have seen have helped our clients in terms of our practice, in terms of improving outcomes for their families. By way of introduction, for those of you that are not familiar with IUE, I just want to give a really brief introduction, if that's okay. So I'll just flip over the slide. Sorry, this is my first webinar on this. So that's IUE's vision: healthy, strong, vibrant Aboriginal and Torres Strait Islander children, families and communities. We are primarily a health organisation. Our legal service is not independent of IUE as a separate entity, but we are a service offering within the Institute. IUE has been around now for 12 years. We have clinical services in the Moreton region. So our medical clinics are in Deception Bay, Margate, Strathpine, Morayfield, and Caboolture, and they are primarily where we go to see our clients. Our clients are referred to us from our doctors, our allied health workers and social workers as well. So we don't have a separate legal clinic. We simply go to where our medical clinics are, and we also have a clinic in Goodna, and we attend our birthing in our community centres in Salisbury, and we have one as well on the north side. So they're the places where we tend to go and where our clients are referred, as well as the elders, the respite services that we run on the north side of Brisbane. In terms of us as a service, we are an accredited community legal centre. We were the 34th community legal centre, and we got that in 2019. Was that Simone? Yes. Yeah. And the areas that we operate are in family law, domestic violence, minor debt matters, education, tenancy, child safety, elder abuse. We don't assist with criminal matters, migration and major civil matters. We tend to refer those matters out and provide options for clients to seek other services. So for us, being able to have good working relationships with other community legal services are really important for us. In terms of our clients, where we see them, again, as I say, we go to our clinics where the clients are familiar already with the Aboriginal community controlled medical clinics. In terms of statistics, as I said, we're not experts in the area of child protection, and as you can see from our stats, child safety matters makes up about 7% of what we do. The majority of what we do is family law, DV and tenancy. However, in terms of family law and tenancy, we have identified risk factors in there that have triggered intervention. So, for example, the risk of homelessness in tenancy can trigger child safety interventions, because obviously a family being homeless is a risk to the care and well-being of children. Just flicking through, just some statistics there in terms of our clients. Primarily our clients have been female, because the pilot, when we started, targeted mums with children in the Moreton region. However, as the service has expanded, we have seen an increased number of people, including men, who are needing our help as well. And just a little bit more on those demographics. But the main things I really wanted to share with you today are, as I mentioned, the systemic issues, the risk factors that can trigger interventions, and approaches to legal practice. If you've got any questions, please, by all means, type them in the chat. And at the end of the presentation, we'll aim to address those questions. And if we can't answer your questions today, we'll be more than happy to have a yarn at a later time. So in terms of the systemic issues that we've identified, one of the issues that we've identified is the lack of following due process. What I mean by that is failing to serve documents within a reasonable time before a court date. And the other one is not informing families of court dates. I want to touch on the failure to serve documents within a reasonable time. A lot of these vulnerable families may be illiterate. They're already feeling overwhelmed with the fact that their children have been taken from their care. When they receive documents that are, up to 200 pages, they can feel very, very overwhelmed, particularly when it's being served on them, say, 2 days before a court date. This can be triggering for parents. They can feel powerless. And our clients have stated to us that it can make them feel as though that they've got no hope in being able to be reunified with their children. And it can it can sometimes get them to think that their only option is to agree to orders. And sometimes that's not always in their best interest. Our aim is always to give clients an opportunity to know the choices and options that are available to them. And we're realistic. We don't set them up to fail. We say to them, look, this situation is difficult, and you know, it is likely that potential orders are going to be made, but at the end of the day, they have the option and they have the choice, and we give them the autonomy to make decisions for themselves. And so, you know, the difficulty in having documents served to you 2 days before is definitely overwhelming. The other thing I mentioned is about the fact that sometimes parents are not informed of court dates. Now, I'm not talking about situations where the parents' whereabouts are unknown. These are parties that are represented, and they you know, the DCPL has all the details of where the parties are, but they're not being informed of court dates. Sometimes they're not even, they're told not to attend court. And what we see for clients is that when a magistrate in the children's court considers these matters and a person does not turn up, by inference, it can indicate to them that a parent is not willing and able to care for their children, by inference of the fact that they are not attending court mentions and court dates when they are due. So it's really important that, you know, for us, when we are working with our social workers, some of our social workers are working with clients that are represented by other legal services, because as a pro bono service, we don't provide ongoing legal representation. So we understand that our ability to assist can be limited. Sometimes our social workers come to us just for a yarn about what they can do to help their clients engage better with other legal services, and we always want to give the best advice we can so that the client at the end of the day gets the best outcome in terms of access to legal services. And we say to them, you know, speak to your lawyer about court dates, and if those lawyers don't know, then you need to start engaging with the department and ask for those court dates. Sometimes our social workers have been the one to find out the court dates as well. So for us, in terms of due process, these are the systemic issues that we have found, and we have raised this as well with the department, so they're well aware that these are the problems that some of our families have faced. The other thing in terms of systemic issues is the way family and domestic violence has been handled by the service centres. What I mean by this is in situations where you've got a parent who's got the care of the children who's in a domestic violence relationship. And what can happen in some instances is we've had, say, for example, the mothers being considered to be a risk to the children because of the fact that their partner has perpetrated DV, and by her choosing to be in a relationship with a person who's perpetrated DV, the mother can be seen as a risk factor. And at times, children have been taken from the mother because of that risk factor when she herself is not the perpetrator of DV. And again, these are things that we have raised with the department in the past. Most of you are aware of the Not Now, Not Ever report in 2015, which had a number of recommendations that came out of that. And we're aware that child safety's ongoing actions are underpinned and guided by the Domestic and Family Violence Prevention Strategy 2016-2026, which essentially provides a framework for recognising domestic and family violence and what supports are needed for women and children. We're hopeful about these things being established on paper. However, we believe more work needs to be done. So, for example, a conversation that I had with a service manager indicated to me, and this is recent, that in terms of one particular matter, I asked whether the domestic and family violence framework had been applied in this particular family situation, and they admitted that their service centre had only recently, in the last 6 months, started adopting the domestic and family violence framework, and that if the domestic and family violence framework had been applied in this family situation, that the situation would have been different for the family. So the department themselves have recognised that there are areas for improvement in terms of the way they address domestic and family violence. In terms of another systemic issue we've identified is in terms of when there are orders in place and parents, so when I say orders, these are short-term orders that are up to 2 years or the long-term orders, and the department has made decisions about the amount of time that families can spend with their children, that parents can spend with their children. What we have encountered with clients that have been referred to us is clients that have struggled for many years to have increased time with their children. They have been given many chances to have meetings, and they've asked for increased time, but it's met with a no or not now, and it keeps getting delayed. And the parents are willing to do whatever they can, whether it's travel 2 hours by public transport to the other side of town to see their children. But there have been instances when the child safety officers have said no, not yet, not appropriate, etc. So the clients come to us wanting to get advice on how to get these decisions reviewed. What we try to do when we work with these clients is to get them to speak with the department first, escalate the matter to the team leader, and if they're not satisfied with the decision of the team leader, to go further to the manager of that service centre. And if they're still not satisfied, using the available avenues through QCAP with reviewable decisions. And we have seen successful outcomes in terms of escalating a matter to QCAT, where ultimately the matter can be disputed successfully without a hearing, but at compulsory conference. So for us, it shouldn't take getting to QCAT for a change in the situation when that was something that could have been negotiated at the centre level. So that's one of the systemic issues. The other one is the child placement principle. As many of you are aware, one of the principles out there is to keep Aboriginal and Torres Strait Islander children with their families as much as possible, and for the children to remain connected with their community and culture. What we've experienced from our clients in terms of their feedback is they don't feel that there has been adequate that there's been adequate efforts in terms of placing children with culturally appropriate families or with their kin. And sometimes we recognise that, you know, there's a shortage on carers out there. So sometimes children will have to be placed with non-Indigenous families. But one of the other things in terms of children who are on those 2-year orders or long-term orders is about how the service centres work with the carers, the non-Indigenous carers, about ensuring the children have connection to family, culture and community. We have had clients come to us say that they've been refused the opportunity to take their children to NAIDOC Week. And you know, these are important events that Aboriginal and Torres Strait Islander children should be able to enjoy with their families. And I guess from my perspective, it's just about advocating for the clients and giving them a voice. So when their voice is not being heard, that's when we can step in and participate in those meetings and advocate for them. And obviously reviewable decisions. Again, if those cultural requests aren't being adhered to, or there's just no flexibility about the cultural requests, such as children participating in sorry business, if those things are not being adhered to, then ultimately those are reviewable decisions. So we advocate where we can and progress and escalate things. But in terms of that, you know, one of the things that we've encountered as well is, you know, we've been told by clients that the minimum thing that carers, non-Indigenous carers, do is read Aboriginal books to children. Well, that's not enough. There needs to be more, and certainly the department needs to work with their families and cultural advisors, as well as you know, leaders in the community, in the Aboriginal and Torres Strait Islander community, to actually work out what's going to be in the best interest of those children, to ensure that their identity in their culture and their community is retained, because we recognise that sometimes they can't be placed with kin. And that they have to go with non-Indigenous families, but there needs to be sensitivity around cultural placements. The other thing that we have encountered is the practice of newborn babies being removed from the care of the mother while the mother is still in hospital with the child who's recovering within hours or days after a birth. This is traumatic for the mothers and for the little babies. Particularly when, you know, there's so many studies around the benefit of a child being able to have that skin contact with the mother and being able to breastfeed. Now, you know, we recognise that interventions may need to happen, but in terms of a hospital context where children are being taken within hours after birth, there needs to be recognition about whether or not that is actually in the best interest of the child and the best interest of the mother, and what supports are needed to ensure that that baby and that mother are given the proper support and care within the hospital context. And I know that may be controversial to people, but it is happening. You know, some babies are being taken within hours after birth, and it is very, very, very traumatic. For us, as a legal service, we're connected in a health organisation that has birthing in our community programs. So many of our mums have the opportunity to be connected to our midwives. Pre-birth and post-birth, we have the ANFPP Nurse Partnership Program, where the nurses stay with the mothers and the babies for 2 years after birth. So these are the things that we see. If there's risk factors, they need wraparound services, and we feel privileged that that is something that we can access. But in terms of other services out there, other legal services, if you come across First Nations families and they don't have that wraparound support, you can always refer them to our birthing programs, like Birthing in Our Community. In terms of what I'll move on to now is risk factors, and I've mentioned this. One of the things that I mentioned was homelessness. There are risk factors that will obviously trigger interventions, and when I talk about interventions, I mean in the sense of whether it's a phone call, whether it's an investigation, or more intrusive interventions such as short-term orders or long-term orders. In our experiences, the triggers, the risk factors that have caused for triggering child safety intervention is exposure to family and domestic violence, homelessness, mental health concerns, particularly if parents have had suicidal ideations or even suffering from postnatal depression. A history of alcohol and other drug misuse, criminal history, a parent not being considered to provide proper care, such as children going to school without lunches, or not maintaining the home with a certain level of cleanliness that the department might expect of that parent. Sexual abuse. And the other thing that we've encountered is a parent's history as a child when they were in the care of the department. That has come into play when we have encountered matters where the department is seeking longer term orders for children. And it seems unfair that because that parent was a child of the department, that ultimately that's seen as a negative for them in terms of rearing children, which you know, in terms, if we encounter that, we always refer the parents to as many services as we can. If they're a first-time parent, you know, the Circle of Security parenting programs, there's a range of great programs for parents out there, and we try to connect them in with internal as well as external services to ensure that they can mitigate any of those risk factors where it may work against them in terms of the department deeming them a parent not willing and able. I previously touched on family law and domestic violence. Now, sometimes we get a lot of referrals to family law and DV, and there's no child safety interaction. As part of our practice and our advices, when DV is involved, we don't try to scare the parents, but we say to them, and because of our experiences in terms of these things being held against parents, is exposure to DV and what that looks like. In terms of ensuring they get the proper support, safety plans in place, etc., but also providing referral pathways for them to access refuges and family wellbeing workers. In terms of another risk factor is homelessness. So we get a lot of referrals for tenancy as well, and whether that's private housing or department housing, if they're at risk of homelessness, we always say to our clients there's a potential risk of a notification to the department should you become homeless. So as you can see, these are not on the outset child safety matters directly, but have the potential for triggering. With Queensland, you know, as most of you know, there is a housing crisis, particularly with COVID, many families that are on the wait list for the department, and you know, it's quite competitive out there as well in terms of private housing. So we try to connect them in with as many services as we possibly can in terms of mitigating that risk of homelessness. And sometimes mitigating that risk of homelessness might also mean pursuing a matter to QCAT should they consider that their circumstances be unfair, and avoiding that, that Form 12 being issued to them beforehand, and addressing risk factors in that way. The other risk factor that we have seen in terms of a potential intervention is mothers that have had multiple children that have had some form of child safety intervention in the past. This places them at greater risk of potential interventions when they have more children. And despite all the hard work that the mothers do to get their life together, and despite all the wraparound services advocating that the mother is doing well, in some instances, CSOs and team leaders do not deem her to be suitable to care for her child, or if they deem her suitable to care for her baby, they do not deem her suitable to care for more than one child. Which you know, as for any of you who are parents, we all know that it's challenging to raise children, but it seems sometimes the expectations on these mothers seem to be much higher, which is a real shame, because, you know, as parents, we should all be given an opportunity to make mistakes, obviously within reason and not putting our children at risk of harm. But sometimes I think for First Nations families, there is unfair expectations, and for some of our clients, the words they've used, the goalposts seem to keep changing. And that's not my language, that's language from our clients. So in terms of our approaches to legal practice, what we have identified for us that has worked for us is basically, you know, creating a non-judgmental space that says we're here to help you, but we're also here to advise them on their rights and responsibilities and help clients to be realistic about their expectations. We have some hard conversations with our clients, and we say to them, what is it that you want? What is it that you think you can do within the, you know, the scope of the services and the family support you have? And we say to them, look, you know, there's no shame in saying if you can't do it right now, and that's okay as well. But we say, if you want to fight for your children, we will give you the legal advice. The battle might be difficult, but if that's what you want to do and you want to show that you want to fight for your children, then that's important for your voice to also be heard. So we are realistic about that. It takes a village to raise children, and we recognise that many of these vulnerable families, and when I say vulnerable, for many First Nations people that have been suffering intergenerational trauma that have been perpetuated from one generation to the next, it requires ongoing support, and these vulnerable mums need help. We certainly want to create a space that says, you know, be realistic about what it is that you want to do and what help you need, and we can make referrals. And being non-judgmental means respecting their autonomy. So we give them as much advice as we can. Sometimes we don't agree with their choices, but that for us as a legal service, autonomy. It's all about respecting a First Nations person's right to choose, and that's, you know, for me as a First Nation, as a non-First Nations lawyer, that has been ingrained in me in this practice, and that is the one thing I will always respect, is the autonomy of an Aboriginal and Torres Strait Islander person's ability to make choices for themselves. And for us, it's about informing them of what choices and options they do have in order for them to make properly informed decisions. The other thing I've been talking about is networking with relevant service in terms of creating culturally safe referral pathways. As a health organisation, we, with services ranging from birthing to social health, counselling, support services, we feel privileged that we have access to these things, but we also recognise that there are other services out there that can help families, such as CADA. We make referrals to ATSLs, we make referrals to Pine Rivers, we make referrals to a range of other services where we don't necessarily have that within our organisation. In terms of pregnant mothers, again, as I mentioned to those out there, if you've got pregnant, vulnerable mums that don't have a range of services around them, there's certainly culturally safe birthing in our community programs out there that you can refer them to as well. So, and as well as the Nurse Family Partnership Program that works with families, particularly for first-time mums that need a little bit of that help. And those nurses do the home visits after the post-birth for the first 2 years of the child's life. So in terms of the other thing that we have found has been helpful is networking with the department. As I said, we recognise the importance of the role that child safety plays in terms of protecting children. And we have networked with centre managers. We've been in contact with the Office of the Child and Family Solicitors. And we've found that opening that dialogue has been helpful in terms of our ability to also help our clients. So it's important to connect with those decision makers. But also, if you find that there is you're not getting an outcome in terms of the CSO or the team leader or the manager, we've been told that as part of the KPIs of each service centre that you can progress a complaint. Which is something that service centre needs to address, and it's part of the KPIs for the department. And the other avenue is also in practice in terms of making a complaint to the Human Rights Commission, particularly in matters concerning First Nations people's rights to have a connection with culture and community. So if there's issues there about for example, the child placement principle that I first mentioned, and that's being ignored, and the department is not taking adequate steps to ensure that the child remains with their Aboriginal and Torres Strait Islander families or kin, then obviously consider the avenues you have to make a complaint to the Human Rights Commission here in Queensland. So I said to Penny that I'd keep it to about half an hour to open up for questions, because I'm sure there will be questions. But Penny, I'll just hand it over to you if there's any questions.
Thanks, Michelle. That's been really interesting and informative for everyone. We haven't had questions coming through yet, so I'm just going to ask everyone to feel free to pop any questions you might have for Michelle and the team just into the questions box, and I'll be able to read them out. So while we're waiting for people to gather their thoughts and pull some questions together, I guess I've got just a couple of things that I thought would be interesting to hear about. And one of those would be whether or not you might be in a position to share with us a little bit of a sort of case study about perhaps where you've had some success for a family that might have been in a very tricky situation, because I think sometimes it's really helpful for people to hear, you know, a bit more of that granularity of how you go about what you do.
Okay, great. Yeah, thanks, Penny. So one particular case study that I have in mind is a mum that had come to us who has had multiple children and multiple interactions with child safety. She didn't have any of her children in her care, but she was pregnant and due to have another child, had the child, and had been trying to increase time with her other children. This particular mum had a history of DV, history of trauma herself, having been sexually abused as a child, and was a child of the department in terms of what happened to her when she was younger. History of mental health issues as well as DV, substance abuse, but she'd worked really, really hard to turn her life around. She'd connected with our Birthing in Our Community program, and through that program she was referred to us because she'd spent a considerable amount of time asking for increased time with her other children who were living 2 hours away. I mentioned before about getting on public transport for 2 hours just to see your children for 1 hour. That was the type of thing she was doing, and she was met with resistance. And there was one particular staff member in the department that had a long history with her, and to some extent we considered that there was some sort of, I guess, prejudicial biases because of this person's long-standing history. And we worked with this mum to ask the department for increased time. That didn't happen, and so we progressed the matter to QCAT. And at QCAT, we were able to reach an outcome at compulsory conference. So it didn't even have to get to hearing stage, but there was a decision to increase the time, but also to remove the conditions that the visits be supervised, because there was some serious restrictions around visits being supervised, which made the times that she could see the children to be a bit unrealistic because of when the CSOs, for example, would be available. So asking for that unsupervised time was also part of it, as well as increased time. Through COVID last year, there were some difficulties as well that this person had experienced, where the department said, well, no, because of COVID, your children can't see you. And we took issue with that, and around, I guess, the health directives of obviously social distancing and all of that, we were able to negotiate visits at the mother's home outdoors, so the CSO could also be safe within, socially distanced, space. And we supported the mother through that, and she was able to have that time with the children. So that's one case study that I can share with you. Simone, is there anything you want to share?
Sorry. In relation to that case study as well, if we go further in relation to, as you know, we're a health justice partnership. With our system of care and wraparound services, we're able to really provide ongoing and long-term support in relation to mitigating all of those factors and safety concerns that the department tend to raise in relation to our mob families. This has proven quite successful in the way that we handle and have the opportunity to be able to deal with that First Nation lens as well, because as we know, one of the biggest hurdles we need to address is that parent willing and able. So if we're able to address the raised concerns and considerations of the department, that system of care and our wraparound services, as Michelle has said before, where we provide ongoing and sometimes support from 1 to 2 years, has proven quite successful and quite beneficial in the way that obviously we handle these matters as well.
It's so interesting to hear from you both around that. Thank you so much for sharing. And I think one of the things that's really clear is, as you've just emphasised, Simone, is the importance of the wraparound care and that wraparound model, which I think is being increasingly understood as best practice in the space of working with First Nations families. And I think for those of us on the webinar who are not in that situation of having sort of inbuilt support through a joined up agency, I think there's opportunities to think about how they can partner with or join with other services within the local area that might be able to start to provide that, at least informally. And I know you've mentioned as well a referral pathway with Pine Rivers Community Legal Service. So we do have a few questions that have come through now. But I might circle back in a while if we've got time to chat a little bit more about what's involved in referral pathways that provide that culturally safe space for people, because I think that's a really interesting issue to dig into as well. But I'm going to come to some of the questions that have come through now. So this is a question from Rachel. Are there any dedicated Aboriginal and Torres Strait Islander people positions in the department in OCFOSS or DCPL?
Rachel, thank you for that question. I mean, I guess that's something that the department can answer, but we do know of cultural advisors that work with the department. That's one particular role that I'm aware of that are specifically Aboriginal and Torres Strait Islander specific roles. But in terms of those other areas, that's out of my, I guess, something that's a question to be asked of the department.
Okay. All right. Thanks, Michelle. So we've now got a question from Colleen. At what point should families seek legal advice, and what interventions by the department are initiated, and how successful is it?
Oh, look, I think, Colleen, thank you so much for that. That's probably a whole nother seminar. But look, in terms of at what point, at any point, particularly where, say, for example, there's no child safety intervention where there's a risk of homelessness, but there's potential. So they should always be getting legal advice when there's any risk factors there that could trigger an intervention. Early advice so that they are aware of what things, because some families don't even know what things they need to address. And as I said, a lot, some of the mums may be illiterate, and even if child safety have provided them with the paperwork, they just can't get their head around it. And sometimes there's this feeling of shame not to ask for help because they feel embarrassed. So I think if you are encountering anybody that is experiencing a potential trigger for intervention, definitely get legal advice. But my thing is get legal advice at any time, because what I said before about autonomy, the more a person knows about what options they have, I think the better informed they can be to make informed decisions, if that makes sense. The next question is about what types of interventions. Now, the types of interventions start from, as I said, a phone conversation, which basically there's a notification that child safety receives, and they have a conversation with the family. If they consider that more needs to happen, then there might be an investigation. If a removal is required, then they'll apply for a temporary assessment order, which lasts for 3 days. And if more is required, they'll apply for a court assessment order, a KO. So TAOs and KOs, a KO will be for 28 days, after which time they'll then consider whether more intrusive interventions. And if the department feels they can work with the family, sometimes they'll just establish a safety plan or a plan with the family over 12 months. But if more intrusive interventions are needed, then the DCPL will step in and apply for short-term orders, which last for 2 years. Now, in the current legislation, they can't extend those 2-year orders. So if reunification does not happen, the DCPL will step in and apply for longer-term orders. I hope that answers your question, Colleen.
Great, thanks, Michelle. It's a very comprehensive answer, so thank you. This question comes from Erica. She says she's interested in hearing any advice you have for appearing in QCAT and contact decisions.
Okay, thank you, Erica. So in terms of appearing in QCAT, as I mentioned before, the first step before going to QCAT is take issue with the decision maker first, which is child safety. So the first level is to approach the CSO. If you're not getting anywhere with the CSO, go to the team leader. If you don't get anywhere with the team leader, go to the service centre manager. If you're not getting anywhere with the service centre manager, you can lodge a complaint. And at the same time, you can consider whether it's a reviewable decision. So if you've got a matter where there's proceedings in the children's court, QCAT will not touch a reviewable decision in relation to that particular child. So just be aware of that. But in terms of reviewable decisions, there are certain decisions such as contact, where there are existing orders already for a child and a parent is not getting increased contact with that child and they're not happy with that decision, then you can ultimately apply to QCAT to have that decision reviewed. Now, when child safety don't have specific lawyers that go, they have workers that will appear at QCAT. But if you as a pro bono lawyer have capacity to go and you've sought leave from QCAT to appear, we have done that. And in most cases, they're more than happy to do so, particularly if your client is not able to speak for themselves or they may feel overwhelmed by the process. We certainly encourage you to seek leave from QCAT to appear. Usually child safety don't take issue with that, particularly given the vulnerabilities of a lot of our clients. So I hope that answers your question, Erica.
Great, thanks, Michelle. The next question comes from Edward. And he asks, how is culturally accepted physical punishment / discipline of children and child intervention dealt with, including with child removal?
So how, sorry, could you just say that question again?
Sure. How is culturally accepted physical punishment or discipline of children and child intervention dealt with, including in relation to child removal? So it's really...
Did you want to...
Yeah.
Gee, that's a hard question to answer because obviously, you know, if they're matters that have come up when we are dealing with our families and our mob mums in relation to what risk factors have been identified. I think the best way to answer that is that in a lot of the removal situations and department anonymous notifications that potentially are being made, a lot of our family haven't realised, you know, from a cultural perspective and in relation to cultural practices and how families are different, that it was actually a problem. So I think that if that answers your question, that, you know, that's a hard one to answer. Obviously, it does become a concern because within the scope of interactions and notifications, it's seen potentially as abuse. Whereas, like we said before, there are many a times when this behaviour has been risen and raised as a contributing safety concern and factor that it wasn't actually in relation to that parent's knowledge something that they actually deemed would be a concern. But obviously it does raise some significant issues that we have seen raised over the past few years in relation to the concerns that have been raised.
Okay, thanks, Simone. So this question comes from Denver. What steps should we take as students in order to prepare ourselves for the industry as it operates today?
Denver, what a question. Thank you for your question. And it's really good that you're wanting to know how to prepare. That's a really hard one. Get as much experience in the pro bono field. If you can get placements, get as much exposure and experience. In terms of working with families in this field, you're going to experience a lot of families who've experienced significant trauma, and that can be very, very challenging. So the thing that I can say is get as much experience, seek out some mentors in the community legal field, and certainly get as much experience, because nothing at uni will prepare you for that. Sure, you can get to know the law, but nothing prepares you more than practice, and exposure to more matters. And if you can get placement, we encourage you to do so.
Great. Thanks, Michelle. Our next question comes from Jordan, and it's got quite a few parts in it. So I'll read it all through, and then if we want to break it down, we can do that. So the question is, what legal provisions do child safety generally use to remove children at those early stages, for example, immediately post-birth, as you've described? And of those factors, which provisions are proving the most damaging or problematic? Hold on, I'm just getting that. What would you suggest that other individuals or organisations do to contribute to raising awareness about the effects of these provisions with a view to any ongoing law reform efforts?
So could you say that last part again, Penny, just the last part?
Yeah, sure. So it's about whether you've got any suggestions about what other individuals or organisations can do in terms of raising awareness about the effects, the negative effects of these provisions, particularly taking children when they're very young, that would support ongoing law reform in this area.
Well, that's it's a hard question to answer to some extent. I guess in relation to legal provisions immediately, obviously, from our learnings and what we're finding is that, and I guess as a mob woman, I will say this, there's a lot of provisions, I guess, and I guess harsher terms and conditions sometimes that are placed upon our families when they are first taken from the hospitals. Obviously, to some extent, they can be quite a shock. Obviously, when a child is moved and the mother is still in hospital, that when we have wraparound services already around them, it becomes quite frustrating to all concerned in relation to these matters and how we deal with them daily, especially when, we know there are parents willing and able, they have the wraparound services, and to be quite frankly, a lot of those concerns or what they say are anonymous notifications are not justified or substantiated by evidence and particular, I guess, warranted removal. I guess in relation to raising awareness and effects, we think about it every day in relation to law reform. I guess, speaking about it, always having those yarns and those fully frank yarns in relation to this matter until you fully, I guess, address these matters every day. It's very hard to say or to answer your questions. In relation, what we've found the most, is with a Section 18 potential removal where they say there's immediate risks. Sometimes our mums are first-time mothers. They, as Michelle has said before, they were unfortunately a product of the department prior. Because they were a product of the department prior, we see that some of our mums' children are removed. They're not provided an opportunity to be parents. That bonding stage, obviously, an attachment period is then taken. Where then obviously when time passes by, or if they drag their heels or come up with some other kind of I guess, concerns that they raise at a later stage then account for further removal away from the mum because of attachment issues. So I guess one of the biggest things, I guess, that we can say in relation to reform, you know, is really looking at it from a systemic issue, you know, not always believing what we're told, I guess. And I don't know really what to say, you know, because what they deem to be a child at risk straight up, if you're removed from a thing, there's never been that opportunity in some circumstances to prove you can be a mum or a family. So I find that a hard question to answer as well. So.
Just Simone was touching on Section 18 of the Child Protection Act, where a child's at immediate risk of harm, and other factors that require the immediate removal of children. I guess what we have to realise is the standards through which it is considered that a child is needed to be removed is somewhat subjective, and sometimes you can have child safety officers that may not be as aware of, I guess, intergenerational trauma, other cultural factors as well, and they can potentially, I want to use the word misjudge, I'm going to use the word misjudge, they can misjudge a situation and potentially place, I guess, negative factors against a parent just simply from the fact that there's a lack of understanding on their part, which is why I said before it's important to network with the department and give them the feedback and advocate for your clients so that there is increased understanding, because I recognise that some of these CSOs may be more experienced than others. Some are coming straight out of uni, which is fine, but there needs to be a level of understanding that there's factors that they may not understand about First Nations families, such as intergenerational trauma, that it could effectively impact things such as mental health, alcohol and drug misuse, and other things due to perhaps a person having been sexually abused themselves when they were younger, which then you know, has triggered homelessness and a whole bunch of other things that affected their way of life. So sometimes these things can be seen so negatively towards a parent without recognising the context of that intergenerational trauma that the person has suffered. So I guess for me, it's about networking and keeping each other informed, because they won't know what they don't know unless we tell them, if that makes sense. Does that help? Sorry, Jordan.
Yeah. No, it's a great answer. Thank you to both of you. And I guess what occurs to me is if organisations want to be adding their voices and supporting, you know, law reform efforts in this space, is to be getting connected with organisations like IUE and other First Nations organisations working in this space is one of the, you know, most important things to do at the outset. So, and Jordan has said, yes, thanks, that's great. So thank you very much, Jordan. So let me just see, we've got a few more questions. We've got a little bit more time to get through a few more. We've got a question here from Rebecca who asks, who is able to represent a family at court whose children have been removed? Might they be represented by a CLC or a private lawyer?
Yep. So in relation to that, Rebecca, that's a really great question. Who's able to represent a family? So we always say to families, don't self-represent because some of them have no choice because they can't get legal representation. At the Children's Court, I'm aware that in some of the courts there are duty lawyers at Brisbane, Caboolture, Ipswich, Pine Rivers and Beenleigh on Monday, Tuesday, Wednesday, Thursdays, Fridays, different days for those different courts. So there are duty lawyers there on the day. The difficulty with clients who go to a duty lawyer in the day is that we recognise duty lawyers are limited with the information they receive on the day. So if a client is not yet represented, what we have done is assisted with potentially drafting an affidavit and a response to an initiating application in relation to orders for their children. So while they're waiting for getting legal representation, either from a community legal centre that has the capacity to do so. So remember I said in the beginning that we don't provide representation. Our discreet assistance may include drafting of court documents. So if we see, depending on the vulnerability of that person and how close their court date is, if we have capacity, and Simone's really good at doing this as a senior principal lawyer, ultimately it's her choice what matters we take on. If we have capacity to do so, we can drop everything and start drafting in order for that parent to be able to make submissions to the court before the court date. And that way, when they go to their duty lawyer, they have their affidavit ready to go, so that the duty lawyer then has some idea of what they need to do to advocate for that person on the day. You asked about whether it's a private lawyer. If they can afford a private lawyer, absolutely great. They can apply to legal aid. Again, legal aid has limitations because of funding. So what we've experienced is in some matters that where clients have had legal aid, the funding ran out, and they're stuck mid-trial or mid-case where there is no final outcome, but the funding has run out. And so that person is stuck, and that's where we've had to step in and sometimes go through a 200-page affidavit. As part, it's bordering on casework, but you know, we provide help where we can to assist that person to be able to have a say in court where they don't have legal representation. So yes, both a private solicitor and community lawyer can do that. Obviously, if a person comes to us and they're already represented, because we sometimes get phone calls saying, I haven't heard from my lawyer, and I said, well, we really can't talk to you because we do not step into the realm of other lawyers, and we just encourage them to reach out and speak to their lawyers, and to also remind clients, you know, you provide instructions to your lawyer, they give advice. And we remind them that don't feel like your lawyers are pushing you into a particular decision if that's not what you want to do. And it's because sometimes the clients come to us not feeling like they have a voice. So we don't want to overstep that professional boundary, but we also remind our clients it's your choice, it's your autonomy, you're the one who gives instructions, and not the other way around.
I guess just further on that note as well, should you get any of our mob families and you have the opportunity to assist with advice, what we've found is the best way to handle those matters on first instance if they aren't represented is to give them those key points. You know, education to us is the key. The more we can educate, the more savvy our mums become, you know, the more information then that they pass on to other mums and community, is just making them fully aware, you know, what is it that the court at that particular stage wants to see if they can seek an adjournment. Are your parent willing and able? What are the key factors of concern and how have you mitigated them? What is your engagement with other services and how long has that engagement gone from? So that sometimes too can be very powerful at that particular stage, which then buys us time to then and other services, if you are assisting, time to be able to then provide external referrals and also look at factors where we can eliminate those concerns through services and mitigating them through evidence.
Terrific. Thank you both so much for your really comprehensive answer. We've had some contact from Emily, who's contacted us from Legal Aid, and she's interested in perhaps connecting with IUE around a potential referral pathway. So I'll circle back to you both sides after the webinar, I think, to see if we can make that connection.
Great, thanks, Penny.
The other thing I thought, just before we finish up, that I thought our people might be interested to hear a little bit more about is you've mentioned a few times the importance of building relationships with the decision makers within the department. And I just wondered if you could talk a little bit about what some of the approaches that you found have been important in doing that successfully.
Robust conversations. Those honest, robust conversations where we set them up, you know, where we know that as professionals, we come into a room, just like we do on this webinar, we're saying we're not, you know, where we let them know these are our day-to-day findings. We understand we've all got a job, you know, we understand the role of the model litigant, we understand that there's multiply disciplinary approaches and perspectives, we understand that there are different focuses and lens, but what is it that's working and what is it that isn't working? Because at the end of the day, it's, you know, how do we keep each of us accountable in relation to how we feel we're delivering services, and in those services, what services are actually being provided, and in that provision of services, where are there gaps? Because we all like to think that we have the best intentions in doing services. I believe everything has room for improvement, but there's nothing, I think there's nothing more powerful than being able to come together as colleagues, having those robust conversations and being totally honest. It's not personal, but it's really good to be able to sit in a collegial way,
yeah,
And from our perspective, someone that deals with it every day from a different perspective, and put forward our findings. I guess that's what I've found to be the best. And just to continuously yarn and talk.
Yeah. Okay. Fantastic. Thanks, Simone, for that really practical advice. I think it's sometimes is really good to hear about, you know, how you actually go about that work, because it sounds like it's a really essential part of achieving, you know, change and good outcomes for clients. So that's all the questions that we've had come through, as well as lots of thank yous to you both for your responses and information. So I would like to add my note of thanks to you both, Michelle and Simone, for presenting to us today on this really important area. So on behalf of everyone wildly clapping and cheering at their computers across the country, our big thanks to you for that. So we're going to end the webinar now, just to let everyone know that a recording will be on the CLCQ website, and the PowerPoints and other material will be available online and from that website as well. So that's it from us for today. Thank you very much for attending. We really appreciate you being a part of it, and thanks again to our wonderful presenters, Michelle and Simone from IUE. Thanks very much.
Thank you.